You're involved in an accident, an auto accident. You have a bad trip and fall. You feel there's medical malpractice. What is involved with regard to having a case? Well, first you need the liability, the responsibility of the person you feel has wronged you, whether that's a slip and fall, medical malpractice, or an automobile accident. Secondly, you have to be injured. The scenario would be that you would pick up the phone and give me a call, and I would listen to the facts and what went on with you. At that point, we would either schedule an appointment to meet, or I would have an investigator come to your home or meet you at a public place to get information with regard to the case. At that point, there could be photographs needed to be taken, or photographs of the scene, or photographs of your injury, etc. At that point, we would discuss your injuries and what you need to do. Do you need to go to a doctor? You may ask, well, I don't have a doctor. At that point, we can review the doctors in your area, and you can pick and choose a doctor that would be convenient for you, where you live at or where you work at. So what would happen is you would treat with the physician if you do have a valid case, meaning the liability is strong, and you would treat, of course, to try to get better. At that point, the records would be coming into my office. We will review the records as they come in. Once you are discharged from the physician's care, I would go and try to get all the records, whether it be from an emergency room, an MRI facility, or the treating doctor. Once those records are compiled, I go through them and we make a package. The package would consist of a letter to the insurance carrier, and that letter would have liability, what occurred, your injuries, how these injuries have affected you, and all your medical treatment. So this would be sent out from the office to the insurance carrier. At that point, the insurance carriers, they don't take these cases immediately. There's a long line, almost like waiting at the post office. And we have to remember, we're all bricks in the wall, but we try to force this and get things done as quick as we can in my office. So we would do that, and the insurance carrier at that point would either accept the claim, deny the claim. If they would accept the claim, they would put a number on that to see the value of the case. And we would discuss the value with you. Prior to that, in the letter that I would forward to the insurance carrier, I will request a specific sum. And we'll see what the insurance carrier comes back with. If we're not happy with what they come back with, the next stage would be litigation. What's litigation? You file something in court. Question may be, well, where do you file in court at? You just can't file anywhere. It depends on a couple of things. Number one, this is called venue. Number one, where the accident occurred, or number two, where the defendant, the person who caused the harm, where they can be served with the legal papers. So you're basically limited to where you can file a lawsuit. Once a lawsuit is filed and the complaint is filed, there are some stages of that. One of the stages is called the discovery phase. The discovery phase is when the attorney for the other side is allowed to send written questions, which are called interrogatories, and also schedule your deposition. A deposition is when you go to an office or the courthouse, and the attorney for the other side is allowed to question you with regard to your past, the accident itself, your history, how the accident has affected you, etc. And these could take anywhere between a half hour till 8 hours or so, 4 hours. It depends upon the complexity of the case. At that point, the defense may also want to have you go to one of their doctors. And this is called a IME, an independent medical exam. But usually I call these a defense medical exam, because they choose who they want you to go to, and they're paying that physician to examine you. So I think there's certainly a slant or a bias with regard to that. And also, getting back a little bit to the depositions, at that point we are able to ask the defendant a variety of questions with regard to the accident, where they were coming from, where they had been before. But we're at the discovery phase now, with the interrogatories, the depositions, and the medical examination. At that point, once everything is in, eventually your time will come for a court date. If it's an arbitration hearing, it should be somewhere within a 9-month period after the case is filed. If it goes to a courthouse, to a jury, it's anywhere between a 1 to 2 year period to get your day in court. At that point, there would be a hearing in front of a judge and maybe in front of a jury. And we would put forth all the cases, everything that went on, and you would be able to tell the jury who are your peers, what went on. And at that point, hopefully there will be a successful conclusion to your matter.